Hello and welcome to Mackenzie Friend. Today we're going to look at overseas travel and flight risk. But first, the usual disclaimer. Whilst I hold a law degree, I choose not to seek admission or practice. Therefore, any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. But firstly, from the Australian Federal Police website, if you're concerned for the safety or welfare of a child, contact your state or territory child welfare service or your local police. If you have immediate concerns that a child is in danger or at risk of abduction, contact the police in your state and territory on 000. For more information on this topic, you can look at my airport watchlist applications video. So the issue today is, what happens if one parent wishes to travel overseas with the child and the other parent opposes such travel? How does the court decide? So, looking briefly at the Family Law Act under 60CA, as usual, in deciding whether to make a particular parenting order in relation to a child, a court must regard the best interest of the child as the paramount consideration. You'll find that in almost every element of family law. Under 60B, which is the objects and principles of the Act, ensuring that children have the benefit of both of their parents having a meaningful involvement in their lives to the maximum extent consistent with the best interest of the child, which means if a parent was to unilaterally relocate overseas, then this would be affected. Also protecting the child from physical or psychological harm, from being subjected to or exposed to abuse, neglect or family violence, and ensuring that children receive adequate and proper parenting to help them achieve their full potential, which might involve the advantage of cultural connection overseas. Also ensuring that parents fulfill their duties and meet their responsibilities concerning the care, welfare and development of their children. So, the basic case on this is a line and line. And these are the considerations the court used to determine whether or not a parent should be allowed to travel overseas. The existence or otherwise of continuing ties between the departing parent and Australia, such as the ownership of real estate, the existence of business interests, or the residence of close family or friends here. The existence and strength of possible motives not to return, including the level of conflict between parents, particularly over child-related issues, and the existence and strength of possible motives to remain in the other nominated country, such as the ownership of real estate, the existence of business interests, or the residence of close family, friends, and or personal friends there, and whether the country of travel is a signatory to the Hague Convention. Hague Convention matters are very difficult, and it is best to avoid them if possible. Also, some other additional considerations is any non-compliance with existing parenting orders. So if a parent goes before the court and shown that they have shown disregard or failed to abide by the orders, the court might not be warm to their application. Also, the age of the child. In this particular matter, the child was very young, and the court determined that the child was incapable of benefiting from exposure to the culture. Also, whether the person they're visiting overseas is so old or has lost capacity such they wouldn't recognise that family member. Also, the ability of the travelling parent to provide a surety or bond if they don't meet the other conditions under line and line, such as the ownership of real estate. Also, the court will seek to determine if there is a genuine flight risk or whether the opposition to travel is without merit. So they will look at the balance of the arguments put forward by each party. If the child is permitted to travel overseas, the court may make orders for surety or a bond to be held in trust by a legal practitioner. That might be somewhere between $20,000 or $30,000, which is maybe what it might cost to run a Hague Convention application. So let's look at some generic or typical orders for overseas travel. In the event that either party wishes to travel overseas with the children during school holiday periods, the other party shall not unreasonably withhold consent of such travel and do all acts and things necessary to facilitate such travel, including the delivery up of the children's passports on the following terms and conditions. The travelling party to provide the other party no less than 2 months' notice of the proposed travel, and within 14 days of such notice, the other party shall provide any objection to such travel and the reasons therefore, and in the balance of objection, consent shall be deemed to have given. So if you don't oppose, consent will be deemed to be given. The travelling party provide to the other party, not less than 1 month prior to departure, a full itinerary including details of the flights and the addresses and telephone numbers of all accommodations in which the children will be staying. Also, the travelling party shall take out comprehensive travel insurance for any period of absence and shall provide the other party a copy of the policy not less than 7 days before departure. And parties do all things necessary to sign all passport application forms and subsequently ensure that the children's passports remain current, and any required renewal shall be done where possible prior to the expiration of any current passport, and the parties shall pay equally the cost of any application or renewal. And finally, the mother, father, lawyer or court registry should ordinarily hold the children's passport but make them available within and for reasonable times upon request by the travelling party to enable them to travel overseas with the children pursuant to this order, such that they have the passports so they can obviously take them and get permits and to visas to enter countries. So, in conclusion, the best interests of the child are paramount. The court will act cautiously if there is a flight risk. Arguments will be confined to the best interest of the child and flight risk. If the child has a passport, it may be appropriate to have the child placed on the family watch list until the matter is determined, as the parent may unilaterally relocate overseas whilst the matter is being determined. Orders sought must include seeking to have the child placed on the watch list so the Australian Federal Police can place the child on the watch list on an interim basis. I hope this helps.